um, even more statutory rape cases where, let's say, for example, someone who is of age, let's say the person is 21 and they have sexual intercourse with someone who is 15 years old, but this person looks like they're 19 years old, and the person even showed them an ID that says that they're 19 years old. Even in that situation, it does not matter. You can still be charged with statutory rape, even though you believe this person to be 19 years old, because no mens rea is required. Now, in situations like that, the only help, if you will, the only help that you would have as a defendant is um, mitigation kind of help. So let's say you were 21, you believe the person was 19 because they showed you an ID, the ID looks legit. You're still going to be charged with statutory rape. However, the judge may be a little more lenient on you because of the facts that were presented. And like, let's say the maximum penalty for statutory rape is 3 years. You may not get 3 years. You may get 1 year, you may get probation, because the facts show that you really didn't intend to have sex with someone that was underage. You intended to have sex with someone that was 19. That's what they showed you on the ID. But it doesn't matter. You can still be charged because statutory rape is a strict liability crime. You can still be charged and convicted. Convicted. Let's see, the next slide here that we're going to discuss is going to be slide 11, concurrence. Concurrence is the actus reus and the mens rea occurring simultaneously. Although it often goes without saying, there is a requirement that the actus reus and the mens rea occur together. This is this is known as concurrence. There are two types of concurrence. There's temporal concurrence and motivational concurrence. Temporal concurrence means that the mens rea must accompany the actus reus in time. Assume, for example, that Bob intends on Tuesday to kill Fred. Assume further that Tuesday turns into Wednesday and Bob changes his mind. If Bob accidentally kills Fred in a hunting accident on Wednesday, he cannot be convicted of first-degree murder because he did not intend to kill Fred at that time. The mens rea must be present when the act is taking place. He may be guilty of another homicide offense, but not first-degree murder, because at the time that he killed him on Wednesday, it was an accident. He didn't have the intent to kill him at the time that the act occurred, so there was no concurrence. But what if Bob intends to kill Fred while they are hunting? Bob shoots Fred, and Fred dies. Then you have the concurrence, because in that example, he had the intent to kill him when they were hunting, and when they were hunting, he shot and he killed him. So there's the actus reus and the mens rea present in that instance. But then let's take it a step further. What if Bob intends to kill Fred while they are hunting? Bob shoots Fred, but Fred manages to escape and get to the hospital for treatment, only to die a few hours later from massive blood loss. Is there a concurrence problem? The answer is no, there is no concurrence problem, because the criminal act and the mens rea occurred together. It doesn't matter that the resulting harm, his death, occurred at a later point. The point is, at the time that the act occurred, the mens rea was also present. Motivational concurrence. Excuse me, what is up with me today and these mispronunciation of these words? Motivational concurrence requires that the mens rea be linked to the actus reus it is intended to accompany. In other words, the mens rea is actually the motivating force behind the actus reus. So let's return to the hunting example where Bob now intends to kill Fred during their hunting trip. While hunting, however, Bob accidentally shoots Fred, who he mistakenly believes is a deer moving through the brush. While the temporal concurrence is arguably present, the motivational concurrence is lacking. Now, this is all rather tedious, but in the end, there is a simple point. For someone to be guilty of a particular crime, there can be no mismatch between the mens rea and the actus reus. The next slide, causation. Causation, the requirement that the defendant is responsible for harm, applies only to result crimes. In other words, the causation requirement does not exist in the case of conduct crimes because conduct crimes do not require a harmful result. In addition, causation inquiries usually come up only in homicide prosecutions, as more often than not, it is clear who caused the harm in other result crimes, for example, a rape crime. Requiring a causation element in certain crimes serves a protective function. Imagine a situation in which any person who was near a homicide could be prosecuted for it. This would this would certainly be unfair, especially if one person was responsible for the act. The causation requirement thus helps to ensure that the actual offender is prosecuted and convicted, not some innocent party. Now, there are two types of causation that we are going to address here. We're going to address factual causation and legal causation. So we're going to start with factual causation. It requires that there can be no criminal liability for a resulting harm unless it can be shown that the defendant's conduct was the cause in fact of the prohibited result. In order to determine factual causation, courts typically apply a but-for test. It requires answering a simple question. But for the defendant's actions, would the resulting harm have occurred? If the answer is no, then the defendant will be liable. Consider this example that comes from your book. Sarah pulls a gun on Anne, shoots Anne in the chest, and Anne dies. We ask, but for Sarah shooting the gun, would Anne have died? The answer is most likely no, which means that Sarah was the factual cause of Anne's death. Another complication pertaining to factual causation arises if there are multiple actual causes of someone's death. Assume again that Sarah shot Anne, but Anne survived for a time only to die from a botched medical procedure. Further, assume that a major earthquake struck at the precise moment that the drugs were administered and that everyone in the emergency room, including Anne, was crushed to death. Who or what is the factual cause of Anne's death? We again must ask ourselves, but for Sarah's actions, would Anne have died when she did? And in this case, the answer is arguably yes, because of the emergency room mistake, the botched procedure, and the earthquake. In other words, it is plausible to assert that something else besides Sarah caused Anne's death. It could have either been the botched procedure or the earthquake. In the event that Sarah is prosecuted for murder, the answer to the question could come down to medical testimony. The state would most likely call an expert who would argue that Anne's wounds were serious enough that she would have died regardless of whether surgery occurred. Sarah's defense attorney would probably call an expert to testify that Anne's wounds were not that serious and that the earthquake and or anesthesiologist were responsible. So there, Sarah's attorney has established reasonable doubt as to whether Sarah is the cause, the factual cause of Anne's death. Did Anne die because Sarah shot her or because of the botched procedure and the earthquake that crushed her? So there you have that reasonable doubt. And there you have another event that may erase the causal connection between Sarah and Anne. So that is factual causation, which is also sometimes, called direct causation, because the defendant's acts were the direct cause of the victim's death or injury. Now we turn to legal causation. So we have factual causation, to recap, is concerned with identifying who or what caused a harm. There could be many factual causes, as we saw in the factual causation analysis. But then when we turn to legal causation or proximate causation, we are now concerned with who should be held criminally responsible. We basically ask a simple question: would it be fair to hold the defendant responsible for the crime? If the answer is yes, then the defendant is the legal cause. In other words, the proximate cause of harm is the person who should be accountable for it. To make a distinction between factual and legal causes more clear, we also need to define what it means to be a direct cause and an intervening cause. In most cases, the defendant is the direct cause of the resulting harm. Direct causation occurs when the defendant, and only the defendant, is the causal agent that brings about a harm. An intervening cause, by contrast, is something else besides the actions of the defendant that resulted in the harm after the defendant acted. If there is an intervening cause that is responsible for a resulting harm, the defendant may not be the legal cause of said injury. This is because the court determines that something else is a superseding cause that had a bigger stake in the resulting injury than the defendant. So there are two types of intervening causes. There is a dependent intervening cause and an independent intervening cause. A dependent intervening cause is one that is either intended or reasonably foreseen by the defendant. For example, if a carjacker draws a gun on his victim and demands the keys, but the victim hits the gas pedal and flees, only to be broadsided by a city bus and killed, the carjacker, now defendant, is arguably the one who should be held responsible for the victim's death, even though the victim was hit by a city bus. Why? The intervening cause, namely the victim's flight from the scene, was dependent on the actions of the defendant. And that is because we can assume that if the victim would have been more cautious pulling out into traffic, she would not have been hit by the bus and would not have died. And she would have proceeded more cautiously into the traffic